Morning, everybody. We will get started here in just 1 minute while we wait for everybody to join. All right, we will go ahead and get started. Welcome, everyone. Thank you for joining us. My name is Jessica Mechtenberg, Program Manager of CDPHE's Gamete Bank and Fertility Clinic program. I am joined by Program Assistant Jake Williamson and Compliance Inspector Cindy Blincy. So today's webinar is meant to assist gamete banks, gamete agencies, and fertility clinics in understanding rule requirements and facility responsibilities described in 5 CCR 1005-6, donor conceived persons and gamete banks, or gamete agencies, gamete banks, and fertility clinics. We will cover key dates, applicability, and a variety of questions that the program has received. We will not be taking live questions during this webinar, but we encourage you to submit questions for future webinars through the form that Cindy will drop into the chat, or you can always email the program as well. And you can visit the program website for additional information, links to resources, and program contact information. So let's cover a few housekeeping items before we begin. First off, please mute your microphone and note that the chat is disabled. If you're on the phone, use *6 to mute. Also, please note that this meeting is being recorded. So first, we'll go over some general timelines and key dates. So entities subject to rule must obtain a license from CDPHE by July 1st, 2025 in order to operate in Colorado or send gametes into Colorado. The Gamete Bank and Fertility Clinic program began accepting applications for licensure starting January 1st, 2025, and we ask entities to apply for licensure by no later than April 1st, 2025 to ensure adequate time for processing applications and conducting inspections. And if the program is unable to process all applications and conduct inspections prior to July 1st, provisional licenses may be issued to entities whose applications are awaiting review. And so gametes that meet the following criteria are subject to rule requirements. First, in order for rule to apply, the donor and recipient must be unknown to each other at the time of donation. This means that a gamete agency, gamete bank, or fertility clinic introduced or initiated the match or connection between the donor and recipient, and the donor and recipient did not mutually exchange identifying information. Next, all rule requirements apply to gametes that were matched or collected on or after January 1st, 2025. There are a couple of rule requirements that started earlier than January 1st, and we'll cover those here in a few minutes. Rule applies to any gamete collections or matches performed by an entity located in Colorado. This means that if a Colorado-based agency performs a match between a donor and recipient who are both out of state, rule would still apply. And finally, rule applies to any gametes or embryos that are matched with or provided to a recipient or their medical provider in Colorado. And we'll discuss the definition of provided later in this presentation, as we've received a few questions about that as well. Okay, so we wanted to give a quick note that rule requirements will not be applied retroactively to previously banked gametes and embryos. So gametes and embryos that were banked prior to January 1st, 2025 can still be legally provided to recipients in Colorado, regardless of whether they meet the rule requirements that started on January 1st. However, two rule requirements did start as early as July 1st, 2023, which facilities must follow. And we'll go over those before starting with the Q&As. So for any gametes or embryos that were received by one facility from another facility on or after July 1st, 2023, the entities involved must, upon request, provide the adult donor-conceived person or the parent or guardian of a minor donor-conceived child with the contact information of the separate entity that provided or matched the gametes or embryo. Next, for any gametes or embryos matched or received by a separate facility on or after July 1st, 2024, each facility must permanently maintain the contact information of the separate entity that provided or matched the gametes or embryos. So please take note of those two dates and keep in mind throughout this webinar that when we state that rule does or does not apply, that these 2 points must always be assumed to be true. So now we'll move on to answering some frequently asked questions that the department has received. We also want to make a quick note that we will be using the terms facility and entity interchangeably throughout the presentation, and there's no real difference in the definition of those two terms. What does provide mean in the sense of providing gametes or embryos? So in the context of rule regulations, to provide gametes or embryos, Jake, do you want to hit so the question appears? There we go. In the context of rule regulations, to provide gametes or embryos means to facilitate a match or donation, including a transfer of ownership of gametes or embryos through a business service or transaction. So just to clarify, shipping or transferring gametes or embryos between facilities on behalf of a parent or family who already owns them is not considered providing, as the shipment is not a product of a matching or donation service or transaction. And what constitutes a match according to rule? So rule defines match in a very specific way that might not align with other everyday uses of the term. Rule states that a match is made by a gamete agency, and a match is considered made when an intended recipient parent selects a specific potential donor or agrees to receive a specific potential donor's gametes prior to the collection of the gametes. So this means two things. First, a match always occurs before a gamete collection. And second, selecting gametes which are already collected and cryopreserved is not considered a match. For purposes of monitoring ovum donor cycle limits, what is considered a retrieval cycle? So to be considered a retrieval cycle, the ovum donor must be placed under anesthesia with the intent to retrieve eggs. And now we have a couple of questions about the term donor. So are known donations or directed donations exempt from these laws? And if the individual who produces eggs or sperm is a sexually intimate partner of the intended recipient, is that individual a donor according to rule? So rule only applies to unknown donations, and sexually intimate partners providing gametes are not considered donors according to rule. And will Colorado consider fertility preservation patients to be donors? What if the patient undergoing fertility preservation is under the age of 21? So an individual who underwent fertility preservation prior to the age of 21 may still donate their gametes upon turning 21 as long as all other rule requirements are met, including screening and testing requirements. In this specific case, the individual would be considered a donor once the contract is signed and ownership is transferred to a licensed entity rather than at the time of gamete collection, like with traditional donations. Time of donation. So the legislation requires that donors be at least 21 years of age at the time of donation. How does the state define time of donation? Must the donor be 21 prior to beginning the application process, prior to signing consents, or prior to the physical recovery of gametes? So when gametes are collected for the purpose of donation, the time of donation is the date the contract is signed and gametes are collected. A donor may be under the age of 21 when starting the process, but they must be 21 on both the date the contract is signed and the day the gametes are collected. What is Colorado's definition of good faith efforts? And what is considered best practice for collecting, maintaining, and updating records of the donor's identifying information? So a good faith effort for maintaining and updating donor information is defined in rule as at least 3 attempts to contact the donor by at least 2 different methods, such as phone records, email copies, or certified mail receipts. And specific best practices for maintaining records are determined by each facility and not by the department, but they could, for example, include routine backups of data and self-audits. So we'll go into some frequently asked questions now about record keeping and donor information disclosure. And before we get started, we want to make a quick note that you should always refer to finalized rule or statute to confirm requirements. Language that comes from any other source, including the online bill summary page, may not accurately state the final language of the law passed by legislature. So the bill summary page in particular was written during early drafting stages of Senate Bill 22-224 and doesn't accurately reflect the final wording of the bill. In particular, that bill summary page states that a legally emancipated donor-conceived person under the age of 18 could request the donor's identifying information, identifying information, which doesn't reflect the final statute language. So when in doubt, you can always reach out to our program if you encounter discrepancies, as well as, look at finalized rule and statute. Okay, so are the required records of donor information expected to be stored in a particular format, i.e. paper or electronic? Rule does not require specific methods or formats for maintaining records. Records may be kept electronically, in paper form, or both. However, keep in mind that records must be available for inspections, available to disclose upon request to a donor-conceived person, and permanently retained. Is the use of a third-party database acceptable for storing and updating donor information? The third-party organization would perform follow-ups with donors at least every 3 years on our behalf. So using a third-party database or service to store donor information and request updates from donors is acceptable as long as all rule requirements are met. So the records need to be available upon request to donor-conceived persons, kept in perpetuity, and made available for inspections. The licensed entity would be responsible for ensuring proper policies and procedures are being met by the third-party company to ensure compliance with rule. What are the expectations for documentation of attempts to contact a donor for updated medical information if the donor does not respond to any attempts? If 3 attempts have been made to contact the donor for updates and the donor has not responded, the entity is not required to pursue any further action at that time, but it must continue to retry at least every 3 years in perpetuity. And rule states that if there is no response to the initial contact attempt, the gamete agency, bank, or fertility clinic must provide proof of at least 3 attempts to contact the donor by at least 2 different methods, such as phone records, email copies, or certified mail receipts. And phone record documentation may include a log that lists like attempted calls. Do we have to continue to attempt to update donor information if the donor is deceased? So if a facility has confirmation that a donor is deceased in the form of a death certificate, it may discontinue efforts to update donor information. How will the department track in-home inseminations? So the department will not track home inseminations, pregnancies, or births. Entities that facilitate matches or donations are responsible for tracking pregnancies and maintaining family limits. And records of tracking efforts must be made available to the department for inspection. Good faith efforts described in rule that entities must make to track live births and maintain the 25 family limit include sufficient record keeping, requiring recipient parents to report information on live births, and requesting information from recipient parents on live births. And facilities should also use industry best practices and commercially reasonable methods to account for the number or percentage of live births, whether it's been reported or not by the recipient. How do facilities stay compliant with HIPAA, considering the rule requires disclosure of sensitive personal and medical information? So rule requires donors to consent to disclosure of specific identifying and medical information. By obtaining that donor consent, the disclosure of that information is not a violation of HIPAA. Entities may want to consult with their legal counsel to ensure their consents are comprehensive for that. Should the consent form used to document the donor's agreement to medical and identifying information disclosure be a standalone form, or is it acceptable to include this as part of a larger consent form? Consents to identity disclosure may be addressed either in a standalone document or included in a larger consent form, but it must be made available for inspection when requested by the department. What is a donor's obligation to the donor-conceived people born from their gamete donation? The donor provides the entity with contact information and updates to medical information, but beyond that, they don't have to be involved in the donor-conceived person's life, correct? So that is correct. While the donor is requested to give personal and medical information updates to the entity that facilitated the donation, there are no requirements that the donor must have contact or any type of relationship with the donor conceived people born from their donation. Okay, next up we'll go over some questions relating to embryos. Do the rules apply to embryos created after January 1st, 2025 with anonymous gamete donors that were collected prior to January 1st, 2025? So no, the gamete collection date is what determines rule applicability, not the embryo creation date. So for example, if an embryo that was created on April 1st, 2025 used sperm that was collected on December 1st, 2022, and an egg that was collected on January 15th, 2025, rule would only apply to the egg donation. On the other hand, if both gametes were collected or matched after January 1st, 2025, rule requirements for the embryo would then apply to both donors. And in that case, it's important to note that if the sperm and egg were banked at 2 separate gamete banks, one of the banks would be responsible for complying with rule for the sperm, and the other would need to comply with rule for the eggs. And the 2 different facilities responsible for tracking would be responsible independently for tracking the 25 family limit for each donor separately. So we now have 3 questions and scenarios regarding how rule applies once a recipient family has legal ownership of donated embryos and the storage location or ownership of the embryos then changes. So first, if a recipient moves to Colorado from another state with embryos that were created with gametes donated after January 1st, 2025, do rules apply? So no, rule does not apply in this case because the embryos are now entering the state as personal possessions of the recipient, and the entity is only transferring the embryos for the family. They are not entering the state as products of a matching or donation service provided by the entity. And in this case, the matching, collection, creation, and provision of the embryos has already occurred prior to the recipient entering the state. Okay, the next scenario. A recipient family located outside of Colorado created embryos using gametes that were collected and donated outside of Colorado on January 1st, 2025. Because the gamete collection and donation occurred outside of Colorado, the gamete donation did not comply with Colorado law. That family is now complete, and they wish to donate their remaining embryos to friends that live in Colorado. Does rule apply to those Colorados? And is the out-of-state bank allowed to ship those embryos into a Colorado facility, even though the embryos don't comply with rule? So rule does not apply, as the transfer of ownership is not facilitated by the bank, and the transfer is a known donation between families. The embryos in this scenario are owned by the original recipient and are only being stored at the bank. And although the bank may assist with the transportation of the embryos aren't owned by the bank or being provided as the product of a match or donation, and therefore not regulated products of a business transaction. Okay, and finally, after completing their own family using embryos created from donor gametes collected after January 1st, 2025, a family donates their leftover embryos back to the bank that is storing them. The bank now has legal ownership of them. Are the embryos now subject to rule? Yes, the embryos are now subject to rule. Once a bank has legal ownership of the embryos, rule requirements will apply again. Okay, now we'll move on to some questions regarding what happens when multiple facilities are involved and who bears what responsibility. So we receive a lot of questions about which facility is responsible for rule requirements when multiple facilities are involved in a match or donation. So we want to provide some clarity before jumping into the questions. So it's important to remember that when multiple facilities are involved, such as when an entity sends gametes to another entity, the primary entity that facilitated the match or donation is going to be responsible for the majority of rule requirements. So on this slide here, we have information about the primary facility and the secondary facility, what they might be responsible for in the service, and then what rule responsibilities they have. So the primary facility is often, but not always, a matching agency. And it's going to be responsible for all major rule requirements, including collecting, maintaining, and disclosing donor information to donor-conceived people, obtaining consents, updating and maintaining records, maintaining the 25 family limit, and providing educational materials. And there may be two primary entities involved with an embryo donation, for example, one for the sperm and one for the egg. And then the secondary facilities involved are the ones that don't facilitate the match or donation, but they might perform retrieval procedures on behalf of a matching agency, or they might receive the gametes or embryos and perform ART procedures after a match or donation has occurred. And so those facilities are only responsible for collecting contact information of the other entities, having a procedure to maintain that information in perpetuity, and providing that information to donor-conceived people upon request. And if they are the facility collecting gametes, then they would also need to provide the gamete screening and testing results to the entity that performed the match. And both primary and secondary facilities would need to obtain a license. So we have 3 questions here related to which facility bears the responsibility for the major rule requirements. So first, when embryos are transferred between IVF facilities, which facility is responsible for disclosing donor information to the donor conceived person? The clinic that created the donated embryos or the clinic that is involved in donating the embryos? Next, if gametes or embryos are transferred to our clinic in Colorado, are we responsible for maintaining and updating medical records and identifying information, or is that the responsibility of the originating clinic? And finally, when an oocyte donor is working with a separate agency, which entity is responsible for compliance with the law? Which entity is responsible for following up with the donor at least every 3 years? And in all 3 of these scenarios, the primary entity that facilitated the match or donation is responsible for the major rule requirements, including obtaining consents for disclosure, updating donor information, disclosing donor information, and maintaining the 25 family limit. Both the receiving and providing entities must record, maintain, and disclose upon request the information of the other entity involved. If a donation occurs at an out-of-state facility and is sent to a facility in Colorado, which facility is responsible for following up with the donor with donor information at least every 3 years? So facility location does not impact which entity is responsible for collecting, maintaining, and disclosing donor information. The primary entity is responsible for those requirements. Next slide. There we go. We are an egg bank that uses other clinics to perform egg retrieval and vitrification services on our behalf. All collection of donor information, consents, etc., is performed by us, and the clinics are not involved with working with recipient parents or any other part of the process. The clinics send the frozen eggs to our bank, which our clients may purchase at a later date. Would these clinics also need licensure or just us? So the clinics would not need a license if they are only performing egg retrievals on your behalf for eggs to be banked at your facility for future use. However, if the clinics are performing egg retrievals for a matching service that you are providing, then they would need to obtain a license and comply with rule. How does the location of the recipient parents impact who needs to comply with requirements of rule? So location of recipient parents does not impact which entity is responsible for compliance. And on top of that, recipient parents are not responsible for ensuring requirements are being met. The entity that facilitates the match or donation is responsible for ensuring major rule requirements are being followed. Any secondary entities that performed the collection or ART procedures would then be responsible for collecting and disclosing the information of the primary entity that facilitated the match. Okay, next up, some questions about out-of-state facilities and donations. So what gamete facilities outside of Colorado need to be licensed with Colorado? Does only the location that physically ships the sperm and oocytes into the state of Colorado need a license, or do all locations that procure specimens need licenses? So out-of-state facilities are required to be licensed with Colorado if they send gametes or embryos into the state as part of a match or donation, or if they facilitate matches with recipients in Colorado. If facilities are part of a larger network, each individual facility that provides gametes to recipients in Colorado would need to obtain a license. Do rules apply to Colorado residents only? what are the requirements for gametes or embryos shipped out of state? We have several patients from all over the country that use our Colorado office for services. So rule applies to gametes provided to recipients in Colorado, regardless of their residency. It also applies to all services relating to unknown gamete donation provided by a gamete bank, fertility clinic, or gamete bank located in Colorado, regardless of the residency or location of the recipient. This means that if a bank or agency located in Colorado is working with a recipient outside of the state, those gametes would still need to comply with rule, as all services provided by Colorado entities are subject to rule. How does the department have the authority to regulate entities outside of Colorado? And also, we are a facility located in Colorado. How do we ensure an out-of-state facility is compliant? So the state of Colorado has the authority to regulate goods and services that come into the state. And the department will only issue a license to a facility that we determine is compliant with law. So to engage in business with an out-of-state facility and ensure they are compliant with rule, you only need to obtain that facility's Colorado license number. Should you discover that another facility is not complying with rule or operating without a license, you may report this to CDPHE. We are an out-of-state bank that plans to get licensed with Colorado. Are we allowed to continue matching and banking gametes that do not comply with Colorado law, as long as those gametes are only provided to recipients in other states? We would also bank gametes that do comply with Colorado law, and we would only provide recipients in Colorado with the gametes that comply. So yes, out-of-state banks licensed with Colorado may continue banking gametes that do not comply with Colorado law, as long as those gametes are not provided to recipients or medical providers in Colorado. And those are all of our questions. Thank you so much for joining us. Additional guidance information, webinars, and other resources will be added to the website when available, including some informational videos regarding the application and inspection processes. Feel free to email us with any additional questions or concerns, and have a great day. Thank you so much.